right, give me the 3, 2, 1.
Hello everyone, I'm Joe Soares here at BizBuzz headquarters.
Hello, this is Mark Leone, and welcome to BizBuzz here at the Comcast Studios in Milford, Mass. Along with co-host Joe Soares. I can't see his hand.
Hello everybody and welcome to BizBuzz. We are discovering local businesses and bringing them home to our communities. I'm your host again, Joe Soares. Joining me, my co-host, Mr. Mark Leone. Mark, how you doing today?
Doing great, thanks, Joe.
Fantastic. We have another great guest for you today, Jay Marsden, attorney here, a local attorney, town of Ashland, Jay?
I'm in Holliston.
You're in Holliston,
right next to a neighbor town.
Neighboring town here. Jay, welcome.
Thank you very much. Great to be here. I appreciate the invitation.
Thanks for coming on the show. So you are an attorney, as I mentioned. Tell us a little bit about yourself, though, Jay, and kind of where you grew up in your background.
Sure. Well, my background, Joe and I used to work together. Years ago, we worked for Fidelity Investments. I worked there for about 17 years. Originally, I'm a bit of a transplant. I'm a city mouse. My wife, who's from Holliston originally, she's a country mouse. And when we first got married, we moved back into the city, and I was finishing up my law degree at night. I went to law school while I was working at Fidelity. And after I spent about 17 years at Fidelity, doing a lot of financial planning, a lot of investment work, I decided that I wanted to take it in a bit of a different direction, and I wanted to practice law full-time. So I left Fidelity. I went to a law firm down on the South Shore. I went to another law firm out on the North Shore, so covered both sides of Boston. And then at some point, the goal had always been to move in this direction and to work on my own. So eventually I hung out a shingle in Holliston where my wife and I live today after we moved out there probably about 6 or 7 years after being married, living in the city.
Well, that's great. So what is your area of specialty?
Well, the area that I practice in is a bit of an offshoot of the work that I was doing when I was at Fidelity. I do a lot of estate planning, I do a lot of probate work, and I do a lot of elder law, which I sort of define for folks as it's very similar to the estate planning concept, but the difference is, as an elder law attorney, you always ask the question, well, what happens if somebody gets sick and needs long-term care? How does the planning need to change? So that's probably the bulk of the practice that I do right now is in that area.
Great. So let's break them down a little bit. I mean, what does the typical estate plan look like?
Sure. Well, I usually break the estate planning down into a couple of areas. They all need a lot of similarities in terms of what should be in each of those plans as people kind of move through the care continuum. But I break them down as there's sort of an estate plan that probably the three of us might need, or somebody a little bit older than us might need, where they need a very basic set of documents to cover a lot of different scenarios. One of them would be a power of attorney, which would cover somebody being incapacitated and needing to make financial decisions for somebody. A healthcare proxy, which would allow somebody to make medical decisions for somebody. This is what's called a HIPAA authorization form. That's basically a form that lets somebody talk to the doctor. It's a permission slip, if you will, to talk to the doctor about somebody's condition. And they also, what I'll draft for a client is I'll draft a living will that I use as a fallback for the healthcare proxy. And the idea is that if the healthcare proxy is ever sitting around wondering, what was this person's wishes, the living will sort of memorializes what that person's wishes are. We will do a will, absolutely, as part of the package, but in a lot of cases what we'll do is a pour-over will, which leaves everything to a trust. And the theory, of course, and you hear it all the time, is I want to make sure I avoid probate. And having a will, common misconception, people think if I have a will I'm going to avoid probate. But really what your will does is give your estate, or give the probate court, if you will, instructions on what should happen to your stuff, if you will. It's really more important to have everything either named with somebody as a joint owner, or to have something in a trust where assets can just pass according to somebody's wishes. So those are the basic documents that we'll do for anybody on any demographic level, young, somebody who's approaching retirement, or somebody who might be a senior or senior plus. But then along the way, I tell people all the time, the health of my clients is really what's going to drive the plan. And so for clients who have some health issues that are kind of on the table and that are in the room, whether it's some issues around somebody's capacity, whether it's Alzheimer's, whether it's early stage dementia, or it's physical limitations, at some point I call that estate planning with care, where we can actually, we can sort of quantify the impact that health issue might have to somebody's estate plan. And then what I'm getting more and more calls on, if you will, or more interest in, is the idea of moving beyond estate planning with care, and we get into sort of full-blown crisis planning, which is somebody picks up the phone and says, my mother had a stroke, my father fell, they're in the hospital, they want to go to a nursing home, and we just don't know what to do. Help us, kind of put the plan together and figure out what we're going to do. So those are sort of the three areas, if you will. There's estate planning with care, and this crisis planning mode. The documents that we want to have in place are the same all the way through. How we use those and how we incorporate them into that plan is going to change depending on the client's health.
Jay, talk a little bit about the crisis planning, because we were talking a little bit before the show, and is it ever too late where something's happened, like for example someone fell and they got to go into a nursing home?
Right.
Is it too late to start the planning process at that point? Have you lost your opportunity, or can you still do planning?
You can always do the planning. It's never too late to do it. What I have found with a lot of my clients, and especially on the elder law side, the way you do things and the order in which you sort of put your plan together is probably as important as just putting the plan together and kind of trying to throw it against the wall and see what happens. So in those situations where somebody will call and say, hey, there's been a crisis in the family, we need to figure out what we're going to do, we will take a step back, and we will, first of all, as I mentioned, we'll talk about what the health of the client looks like. If we're worried that mortality is an issue, our focus may be on just straight probate avoidance. Let's make sure that we can retitle some assets using the documents that we have in place so that we avoid a trip to the probate court and make sure that we can carry out a client's wishes. If the client's health issues don't allow us to do something like that, the plan may then switch to something where we sit down and talk about the family and say, what's going to happen? Is mom or dad going to be able to come home? And if they are going to come home, how do we put in place a plan that allows us to pay for services, home health aides, bring people in and do something like that?
Well, because that's exactly my point. It was kind of what I'm getting at, is the fact that if someone has assets at risk and they become they need that long-term, that custodial care, if you will, that can be very expensive. As we know, I mean, talking maybe potentially $100,000 a year, someone's got to shell out in Medicare, as we know, doesn't cover that. Health insurance is not going to cover that, so it's going to come out of their pocket, so to speak. Now there is insurance for that type of care, but if they don't have that insurance in place, it's too late, of course, at that point. Can you devise a way to help protect those assets?
Yep. Well, you bring up a great point, Joe. The first thing is a lot of people are under the misconception that Medicare is going to take care of these costs. And we try to remind families all the time that the Medicare piece of the puzzle is really only designed to pay for their health insurance or be used as their health insurance while they're in, let's say, the hospital. Once they've been to the hospital, once the hospital has sort of stabilized them and kind of fixed them up, to your point, they will say to them, okay, we need to move you to a rehab facility, we need to figure out what your next steps are going to be if you can't go home, and then you're going to go to a rehab facility. And usually what will happen is Medicare will cover some of your days at that rehab facility, but to your point, at some point in time, the patient, if they cannot go home, they do become sort of a custodial care patient, and the nursing home will be looking for some payment for how mom or dad at that facility is going to be taken care of. And you brought up the number of around $10,000 a month, which is relatively accurate. That's around what most people are going to pay. And for some patients who don't have those resources and can't pay for that, they would be looking to Medicaid to cover the cost of that care at the facility. And they can do planning at that point, depending on what their assets are like. Medicaid has very specific rules. I make the analogy, it's much like going to a tax planner. You know, the tax planner says, this is what the tax code says you can do, this is what the tax code says you as a taxpayer are allowed to have, and this is what you pay. Medicaid works much the same way. There are rules that the Medicaid folks have laid out that says if you are a, for example, single individual, you're allowed to have no more than $2,000 in the bank. Everything above that would be considered over asset, and the expectation is that you would use those assets to pay for your care in the nursing home, and then at some point when you've gone below $2,000, then you could be a Medicaid patient. You can then apply for Mass Health, which is the Medicaid version in Massachusetts. As a spousal entity, as a husband and wife, the numbers are a little bit different. Husband and wives, we always pick on the husbands, by the way. Sorry, guys. It's always the dads that go to the nursing home, so I fall in that category. Dad goes to a nursing home. Mom is allowed to keep her house. It's called sort of a spouse in the house rule we talk about, and say, you're not going to be kicked out of your home. But you're also allowed to have mom, per se, as the one in the community, is allowed to have around $100,000 in her name. Everything above and beyond that is considered excess assets. In Medicaid, we want to look at that and say, well, those are assets that could be used to pay for somebody's care in the nursing home. In a lot of cases, what we'll do is we'll work with clients. There are some things that Mass Health will let you spend your money on. And in many cases, it's things like pre-burial planning, where you want to sit down and make sure that somebody's needs are taken care of in the event somebody does pass away. So what we do as elder law attorneys is we sit down with the family in those situations and walk them through that process to say, we don't know what somebody comes in with. We sit down and we talk about what everybody has. We go over the process. We sort of inventory what their situation looks like, talk about what the health planning might be and how that's going to affect the situation. And then we sit down and we devise a plan. And as an elder law attorney, the challenge, of course, is that the plan that we start down today, that path, absolutely can change on the fly because we don't know what's going to happen. So we try to prepare for a lot of different scenarios. So we always say to clients, we're going to hope for the best and we're going to plan for the worst. Let's put this plan in place and let's figure out where we go from there. So it's never too late to do the planning. I always try to encourage people. Call an elder law attorney if something ever happened, there's a triggering event. Adult children worried about mom and dad and what the plan should look like. The best thing that somebody can do is pre-plan, because there's a lot of things that we can talk about. That's right. That's right. You're not
more options.
Your back isn't up against the wall. There's a lot of things that you can talk about in terms of how to do things, and that goes back to that comment that I made earlier. It's a lot of the planning is involved with what order you try to do different things. And so what we try to do is sit down and try to get to people before there's a triggering event, before there's some crisis that we need to respond to say, what do you, mom, what do you, dad, want to have happen in these different scenarios? Let's plan for that now, because if we can get in front of it, in a lot of cases, we can try to find a solution that works. My goal as an elder law attorney, and I tell people all the time, my goal is to keep my clients in their home as long as possible. That's always the number one objective. That's where people want to be. That's where family can really take part in their care. But if that doesn't work, we sort of move them through the care continuum and try to find resources that can support that. But if it can't work out, it's really important that we know what the next steps are going to be.
Great.
Good point.
Can we talk a little bit about the probate process? I understand someone should have a perfect estate plan, and obviously the elder law side of the planning and or the crisis planning. But I guess there's still a fair amount of people who have maybe an I love you will that they did 50 years ago.
Yep.
They own a house that's in both the husband and wife's name, and it may be titled that, but for however it's titled. And then let's say they have a few CDs and a little bit of an IRA, and so usually one spouse dies first, and then everything goes to the other person. So there's some process that has to happen there with the retitling. And then what also happens is some people will come in and they'll say, okay, now mom died, but we're trying to sell the house, but there's another process that has to go through. So can you just kind of walk through that a little bit?
Happy to do that. Actually, I break the probate process down into sort of two parts. A lot of people think about probate as if I get sick and I pass away, what happens to my stuff, if you will. Probate actually has two avenues, if you will. There's probate while you're alive, and what that means is if you don't have a power of attorney or if you don't have a healthcare proxy and somebody was to get sick, when you go to the facility, whether it's a nursing home or a hospital, if you're unable to have somebody make decisions for you, you'll have to get on the guardianship path, and you will have to go to probate court and you petition the probate court to have a guardian named for you. Who that's going to be, we don't know until we get to court. We try to avoid that as best we can by having those two documents in place. So there's the probate while you're alive piece, which is very important because it's easy to fix that up by having those documents in place. Otherwise, you're kind of throwing caution to the wind and you don't know who's going to get named and how it's going to play out. The second piece, which I think most people are very familiar with, is this idea of probate after you pass away. And the example I use is, we'll pick on Joe. So Joe has a bank account with just his name on it, and if he passes away and somebody goes into the account, we'll pick on you. You go into the bank and say, well, I'm here to help out Joe with all that money in that bank account, and I'm going to take that and I'm going to make sure that gets where it's supposed to go. The bank has no way of knowing whether or not you truly are the person who has the authority to act on that account. So we have to take Joe's will, we have to send it into the probate court, they're going to send back some paperwork.